Hello, I'm Julianne Holt from the Public Defender's Office, and you're watching Tampa Bay Community Network.
Hi, I'm Bill Hodges, and this is Spotlight on Government. And today we're going to be talking with Julianne Holt, who heads up the Public Defender's Office. So good to have you on the program.
Thank you. Good to see you again.
Is it District 13?
It's the Judicial Circuit 13.
Judicial Circuit 13. Give me a little background on the actual public defender kind of idea, because I don't think a lot of countries even have this, do they?
They do not. We were created from a case called Gideon versus Wainwright. And the United States Supreme Court basically said everyone should have a lawyer if they're going to be in the criminal justice system and they're about to lose their liberty in some way. And so what that really was intended to say is, if you don't have the finances to hire a private attorney, and you're facing serious ramifications in a criminal justice system, you should have an attorney. Florida was great. Florida quickly responded and created the public defender system.
Prior to 1968 or the early 60s, if I didn't have the money for a defense, what did I do?
Well, if you were charged with a homicide, the one good thing about Hillsborough County was they were actually appointing private lawyers. And judges would be able to pick up a phone call, a lawyer that they knew, say, hey, this person's charged with a homicide. I want you to come do this. And I want you to, sometimes pro bono, sometimes they might give you a little bit of money, but a formalized, structured situation arose as a result of the Gideon case. And so once Gideon started and we moved forward into the 1972 era where we started to create the system, everything moved forward from there.
Wow, I really expected this would have went well back into the dark realms of the United States history.
No, not at all, not at all.
What bothers me, I guess, when I look at television shows and see public defenders coming up against the state is that even though they're hiring these people or people from your office are going in, do you have the funds and the ability to match what the state can do forensically and all the other things?
Well, there's two separate pots of money. So the forensic part of it is what we call due process funds. That is an area where we have been well funded by the legislature. But then when we turn to our primary budget, the budget that is about 94% salaries, that's where our salaries sit. We are woefully underfunded in that area. We're funded at about a $40,000 FTE, which is a full-time equivalent position. So we have $40,000, and that's what you have to hire a lawyer coming fresh out of law school. Their loans are somewhere over $100,000 quite often. And so from a financial standpoint, we're just not keeping up, number one, with the market for salaries, and there's a tremendous inequity even among government attorneys. And so one of the things that we've tried to do over the last 3 or 4 years is convince the legislature, hey, we need some funding in order to retain lawyers. So it's not just the hiring, but really the real retention issue that we have. About 3 to 5 years, the attorneys just have to leave. They have to go out into either the private sector or they have to go to another governmental agency that pays better salaries. And
so you become a training ground, a constant training ground.
Exactly, exactly. And the idea of career public defenders or career state attorneys is something that is in tremendous jeopardy. A lot of people think it's good to have this in and out of the system, but the practice of criminal law from both sides has become so complicated and so much more difficult and so much more intense in terms of work that you really, the in and out of attorneys affects the quality of work on both sides. And so we really do need to pay attention there.
I had a friend, Jim Vogley, up in Cincinnati, who was a career public defender, not offender.
Defender.
But he was career, and he actually retired from the job finally. But he used to say that every Monday morning he began his week in a drunk tank
Why was that?
Because that's where his clients were.
Aha, there you go. Well, as you know,
That's kind of hard to look at, saying every Monday morning, that's what I'm going to do.
well, I don't think a lot of people realize that our criminal justice system is ongoing every single day of the year. We actually have to appear at first appearance court every single day. There are no holidays and there's no excuse or anything of this sort not to go to those courtrooms. By law and by administrative order, both the prosecutors and the defense lawyers are mandated to be in those courtrooms. So we get up every day and we're addressing everyone that was arrested within the last 24 hours. So unless
Even Saturday and Sunday. huh?
Saturday, Sunday,
The court-
Christmas.
I guess it's naivety on my part, but I didn't think of the court being there on Sunday.
We're there even on holidays. The only time there's an exception is if the governor and the Supreme Court come together and make a decision that because of, for instance, a hurricane, there's going to be danger to the community if you were to be on the roads, and then they'll suspend that court for about 24 hours. But it requires governor and the Supreme Court justice coming
Yeah.
together. Yes.
So if someone is brought in for committing a crime, how fast do they have to get them to court?
Within the first 24 hours. And there the judge determines whether there's probable cause to hold you and determines whether or not you're entitled to a bond, or if a bond has been set, whether it should be increased or decreased.
Again, I've been watching too much television. I thought it was 48 hours to
No.
charge.
Well, to charge, the prosecutor has 21 days to charge you, but formally, you must be before a judge within those first 24 hours to see whether or not you have that probable cause for the arrest. Now,
Then the charge can come later.
the official charge that you'll be facing will come at a later time. And the prosecutor even has the option of saying, even though there might have been probable cause to hold you, I don't think that we should file charges in this case because I don't think there's a substantial likelihood of a conviction. So lots of things can happen in those 21 days.
We hear a lot about negotiating different sentences. Is it like television shows us? Is there a lot of horse trading back and forth?
There's definitely a lot of plea negotiations. The criminal justice system would not be able to sustain itself in any way if you didn't have plea negotiations. But it's not a bartering back and forth sometimes as people think. What we encourage our lawyers to do is we encourage them to read a police report fully and completely. We encourage them to investigate the case. We encourage them to talk to their client about any defenses that exist. One of the things that changed over the last 24 and a half years is we discourage attorneys from allowing clients to enter a plea at their first court appearance after formal charges are filed. And that's because there's not been a full investigation of the case. And if you're in jail, you feel a little bit of pressure to try to get out of jail if somebody offers you probation or says credit for time served. The problem is there's long-term ramifications to those convictions. So we've really discouraged our lawyers from allowing those things to happen. We encourage them to create a relationship with the client and say, let us do our work first and let us make sure that how this case is resolved is how it should be. So to some extent, although you have the plea negotiations, they should be done when both sides are fully aware of what the true facts, the true defenses are in this case, and whether or not the right charges have been actually filed.
Of course, again, my experience with the courts is strictly from television, and we all know that's not good. But maybe that's part of what we can clear up today is some of the misconceptions that we see on TV shows. But I'm thinking to myself, here you've got a young person, most likely ethnic, who doesn't have any money, maybe has some kind of criminal record along the lines, and they offer him 3 years, but if he doesn't take those 3 years, he's facing 25. Seems to me, a lot of times they cave and say, okay, even though I'm not guilty, I'll take the 3. Does this kind of thing happen as much as what we see on television?
I think it would be disingenuous to say that it doesn't happen. And I think that's why, for me, it was important to teach lawyers to slow down a little bit and to make sure that a client really understands what it is that is happening in a case. If you do a good critical analysis of a case, you should be able to determine what can the state prove, what can they not prove. And your negotiations should be built around that. So initially you may be facing 25 years. But once you've concluded all your investigation, you can go to the state and say, you really can't prove an armed robbery, but what you can prove perhaps is a grand theft. So the charges might be reduced, and as a result of that, you go from a very high level punishment to a lower one. What you shouldn't allow anyone to do is plead guilty knowing that the state can't prove the charges, knowing that your client has told you that they're not guilty and trying to intimidate them in any way. And there are some horror stories that have been written across the nation where attorneys will just not even communicate with their client. Communication is the number one thing you need to do, because you need to know not only about this instance, but who's your client, where do they come from? So you just indicated maybe poor. Well, they might have mental health problems.
That's very true.
They might have a substance abuse problem. They might have an alibi. Maybe they were somewhere else. But unless you talk to your client and get to know your client, unless you do that full investigation, you could very well give your client advice that is not in their best interest. And so the quality of lawyering does matter. And that's why proper funding matters.
As I assume caseload matters too. How many people they have, any particular public defender has, that they're actually taking care of. It's like having 1,000 balls in the air.
That's correct. And sometimes people will say to me, well, if so-and-so were representing this person, and I said, let me give you an idea of something. If I'm in private practice and I charge somebody $1 million to represent them, they're going to get a lot of undivided attention, no doubt about it.
True, and probably 3 or 4 lawyers working on the case, or 5 or 6.
And in our office, the first thing you have to realize is you're doing this for the right reason. You're not doing this because of money in any way whatsoever. And so what you have to do is remember that every single case is a person. And every single case not only has your person, the client, but this is affecting witnesses, this is affecting alleged victims of crimes. And so if you're not prepared to give each case the undivided attention that it requires. And one of the things, we don't get paid by the hour. We don't get paid by the hour. Our job is very simple. You do whatever needs to be done for however long it takes you to do it, and the paycheck is the same at the end of it. So it's really got to be someone who really feels that this is their calling. And that's why the in and out of attorneys is not good, because
I would assume that there's a burnout rate there.
I think for some people it is. And that's why I say you've got to try to hire the right folks, because this has to be a calling. I've been doing it for 24 and a half years, plus in private practice another 11 and a half years. I have not burned out on what my passion is, and I have not burned out on what I feel is one of the most important jobs that you can do, and that is represent someone whose life or liberty is at stake. There's nothing to me that you can do that's more important than that. And so you have to be ready for it. You have to be really ready to sacrifice. I was at work yesterday, Sunday, because I needed to.
Well, I guess that led me to my question. How much of your job is administrative and how much of your job is actually now in front of the bench?
Well, now the majority of it is administrative. But what I always do is I always carry, at least at a minimum, a death penalty case. So I work on death penalty cases still.
Okay.
So I have one that's pending now. I just concluded another case last year. I focus mostly on homicide cases at this point of my career. A couple of reasons. Number one, it's the most difficult work, and I think as the head of an agency, you should be willing to do the most difficult work.
I think you're
Number
right.
two, we have a lot of homicide cases with the death penalty as a potential punishment right now, and I'm only one of a handful of lawyers in the office that's qualified to do that work. So it would be wrong for me not to take a part in that workload.
Do you review the cases that your attorneys are doing, or do you have that much time? Time is essential. I mean, let's face it, it'd be nice if you were able to go in depth on every one of those cases. But how many cases a year do you have coming through your office?
Well, anywhere between 50 and 70,000 cases a year. And so do I review every single one?
Through
No.
your office?
Yes.
50 and 70,000. How many attorneys do you have?
120.
my math isn't going to be able to do it.
There's a lot of cases. At
That's
any
a
given
lot
time,
of
at
cases.
any given time, most of the lawyers carry at least 100 cases each. So there's a lot of cases. I'm extremely involved, obviously, in high-profile cases, media cases where there's attention in some way to make sure that everything is moving in the way that
All
it
the
should.
T's are dotted and
Everything should be moving.
I's.
I'm also extremely involved in juvenile direct file cases because those are juveniles that are now sitting in the adult system, so I'm actively involved in those. I take, if we have client concerns or client complaints from either parents or relatives, anything like that, I coordinate that. I'm involved in any time there's a Florida bar grievance that's filed against our lawyers. I get involved in those. So most of my lawyers would tell you they consider my management style to be extremely hands-on. I review conflicts.
from what I've heard about you, that's very true.
I review potential conflicts. I review the expenditure of our due process dollars. And I sit, obviously, on a lot of committees and councils where a lot of cases are sometimes discussed.
Let's talk about how people come to your office. Do they have to be totally indigent? What is the criteria by which people actually come to your office?
You have to meet the statutory guidelines that have been created in Chapter 27, and they're tied into the federal poverty lines. But we're appointed in one of two ways. We're either appointed because you fill out the affidavit of indigency, and the clerk of court, Ms. Frank's office, reviews it and makes a determination on the face of that document that the client qualifies. So we'll be
Okay.
appointed. Or a judge can
So
also
it's
appoint
not
us.
coming to your office to be appointed. They have to go through the court system to be appointed.
That's correct.
Okay.
And if we feel someone's been appointed to us that is not indigent, we have the legal right to ask for a review. And the same way, if someone's been denied our services and we feel that that's not been done properly, we can again ask for a review. An example of something is we may very well represent someone on a case where they own a home and they own a car, but there's been a determination, perhaps, that because of the type of case that is, that they cannot afford to hire a private attorney. They may not have enough equity in the home, they may not have enough equity in the car, and they're charged with a first-degree murder, and everyone's quoting them $50,000, $60,000, $100,000. The court can find that to force that person to hire a private lawyer would create a substantial hardship. And so then the court can say, in spite of them not being totally indigent, we're still going to appoint you.
I guess it's never seemed, and I don't know a way to solve it, it's never seemed quite right. They can arrest someone for something, have you spend $60,000, $100,000 to defend yourself, and have it turn out that you're not guilty. And nobody gives me anything back.
Well, if
I just got to absorb the cost.
If you hired a private lawyer, you're right. You're not going to recoup those attorney's fees, but you can recoup your due process cost, which is not the majority of the money that's usually been spent.
Filings and things like that?
Things like an expert, a mental health expert, or if you hired an investigator, or if you hired a mitigation specialist, you could recoup those funds. But you're absolutely right that can occur.
What are some of the things that you see coming down the pike as far as public defenders? Are there any changes coming up or any changes you'd like to see come up?
Well, I certainly would like to see the legislature open up funding and properly fund our offices and recognize that we're an integral part of the criminal justice system. So I think that's the number one thing.
Sounds unreasonable to say a $40,000 start with an attorney who's spent all that money going to school.
It does, and that certainly is the number one part of it.
Especially when you have a legislature made up of primarily attorneys. I think that's probably the number one job up there.
There are a lot of lawyers. I think a lot of them, though, went to work for public defenders and state attorneys' offices, worked there for a few years, and then left and went off. So I don't think they have a good appreciation of what it's like today.
Or they feel it's part of the dues you pay for the profession.
And that could be. And I think that they sometimes don't have a good appreciation for the quality of work that is being done. We need substantial reform in the criminal justice system. Right now, a person, in my opinion, who is economically challenged in some way, that does cause issues in terms of, are they able to bond out of jail or not bond out of jail? And from an economic standpoint, do you have the ability to actually sit in jail from an economic standpoint for 6 months while your case is being resolved without it having a tremendous impact on your life in the future?
Or your children.
And your children. I think that we need to relook at minimum mandatories and what the unintended consequences were.
I honestly, we pay judges big money to sit on that and decide what the absolute penalty is for it, and to legislate a penalty just makes no sense to me.
Well, I'm a big believer in judicial discretion, and primarily that's because when I started practicing law 36 years ago, that's the way it was. And so I've worked both systems, and you can see, of course, the bad parts of both systems, but to me, your check and balance should be the judge. That's what it should be. And I think that if you don't have reform in this area, I think we're just going to continue to see too many people that are long-term affected by the criminal justice system. I think we need to see a different way of how we look at children in the justice system. And I think we have to really distinguish between what are minor crimes and what are not minor crimes. And I think we need to find a better way to deal with them than the criminal justice system. I think the Hillsborough County School Board did a pretty good job this year of trying to not use the criminal justice system.
Yes.
In place of the discretions that the school system could show. I think that was a positive move.
And police departments working in that same direction, are they not?
And they are. We're now moving forward with adult diversionary programs and juvenile diversionary programs. And a lot of people think that this is a free pass. And Hillsborough County has done things a lot differently. And I tell people, judge Hillsborough County by what we do, because every single one of our diversion programs has not only the punitive piece to it, but it also has the rehabilitative piece to it. So yes, you have quick action in order to say your behavior was wrong. But by the way, it's because you don't have any idea how to deal with conflict. So let's teach you how to deal with a conflict, other than with your fist, or other than with a gun, or other than with a stick.
Or shooting somebody because they threw popcorn at you.
Let's try real hard to deal with what are some real problems that exist. And it's not that we want to substitute for family control in any way, or family, or the way families deal with their children. What we want to do is, in a public setting, there's some behaviors that are appropriate and not appropriate. And so let's teach you how to deal with those things.
But you know, the only paperwork I had to be a father was that I had one once and I was a kid. And if my father didn't do a good job, or I screwed up as a kid, then really a program like this that takes it out of my hands and gives the kid or child a different view of the way to handle things. And the child may, in the family, learn that if you do something wrong, you get slapped upside the head.
Right.
That's the only penalty you get, or the belt comes out. And when you look at it, you say, wait a minute, they're repeating that when they go to school. Somebody mouths off, you slap them.
And you know, that's been an interesting pendulum that has swung in the last 24 years, because for a while there, during my public defender years here, if you were a parent and there were corporal punishment that was being implemented at home, a lot of parents were being charged with that. And we swung the pendulum a little too far, and then we came back and we started saying, okay, you do have to allow parents some discretion. But what you shouldn't allow to be emulated is, you know, the throwing of things at each other, what we now have in terms of domestic violence.
Right.
And I think that when you have an opportunity, when you as a law enforcement agency come into a home and see that there's domestic violence, that's a prime opportunity to try and change behavior for that entire family.
Yes.
And I think we should do a lot better job about that. I think that's where your prevention can really start. If you're going to criminalize it, that's fine, but, and there's been studies back and forth on this. I think that if you know that there's a home where this has been ongoing, I think you have to address every single child there, because there are studies that show that those children are at risk. And today's victim, as a matter of fact, can become tomorrow's defendant, because we've actually had that happen in our office, where we're representing someone who's a defendant, and then the next thing you know, they become the victim, and vice versa.
Well, abused become abusers many times.
And so you have to know that you have to try and change that behavior. And that's one of the things we're trying to do in the juvenile area right now, is we're trying to say with our clients, if you're willing to do some therapy, this is what we want to go to the state attorney and say, hey, state attorney, will you consider this in lieu of putting this person into the system? I think that's important. I think it's imperative. I think that's the way we should look at it. I think it should be a holistic approach. It benefits the community much better than incarceration.
Well, I don't know what it costs anymore. I saw some numbers of keeping someone in jail. But it would seem to me you could do a lot better job if you did what you're talking about. Instead of putting them in jail, putting them out there where they'll learn something and change the behavior.
As long as you focus immediately, and as long as it's long-term enough. It's not anything that I don't think that you necessarily learn.
It's not like traffic school.
No, it isn't. And you're right. And a lot of times.
Which is a joke.
A lot of times people say, why don't you make this available online? Because you need to be physically one-on-one with someone to try and get that person to know that they're actually making progress with you. This criminal justice system, in all of those years, needs to have changed and keep up with the times. It's not just the laws that are passed. It's not just the way you go through the system. You've got to keep up with the way times are changing. What that means is you and I needed to find out about social media, whether we wanted to or not. Right.
Rapidly.
Rapidly. And you've got to be in touch. You have to be able to communicate with a child in their language. You have to be able to communicate with someone who comes from one part of town within their language, their culture. Everything is not equal. Everything is very different. And so you've got to find a way to treat every single case, not as a case, but as a person, because they're a problem that we have an opportunity to solve. Because even if you're not guilty, something got you into the criminal justice system.
Well, the sad part is the recidivism rate. I mean, people keep coming in and out of the system, back and back and back. We don't break that chain.
You have to break it. You do. You have to break it. But I want you to know this. The majority of people that come into the system do not come back. What we hear about is the smaller amount of people.
I thought we had a fairly high recidivism rate.
We do not have that high.
We're going to have to discuss that the next time you come.
We will.
You will come back.
I will come back, and we'll talk about recidivism. But
Julianne Holt, I appreciate your being here.
Thanks for having me.
I'm proud of the work you do with the Public Defender's Office. I think it's really great.
Thank you.
The poor especially need to be treated well in our system, or otherwise they are going to be coming back. Ladies and gentlemen, I'm Bill Hodges. This has been Spotlight on Government. You are unique, you're special, you're great. Tell yourself so often, because you are, and we'll see you on the next Spotlight on Government. And again, Ms. Holt, thank you for being with us.
Thank you, Bill.